here to talk with you about how transfer on death deeds and beneficiary designations can alter your estate plan. Hi, I'm Alec Osland, an attorney at Yanowitz Law Firm, where we help families with wills, trusts, real estate, and probate. Now, transfer on death deeds. Let's take a little bit and talk about what transfer on death deeds are and how they work. A transfer on death deed is a type of deed that someone can fill out while they are living that can identify where their real estate will pass upon their death. This transfer on death deed is then recorded with the property recorder. And when someone has passed away, that beneficiary that's listed on that transfer on death deed can then work with an attorney to fill out additional legal documents that will then be recorded along with a death certificate with the county recorder that then can put the real estate in their name. Now, seems like a great thing, can expedite the process, potentially avoid probate, but there can be some major impacts that can really alter someone's estate plan and potentially mess up the goals that they have. For example, what I mean by messing up the goals that someone has is if someone has completed a will prior and they have a piece of real estate that they've identified in their will should go to their friend Bob, but then later on, if they do a transfer on death deed and they identify that Joe gets this property upon their death, then that property is going to go to Joe because it's identified in that transfer on death deed where that asset is going to pass. So even though Bob is included in the will, Bob is not going to end up with the property. So essentially here, someone's will is only going to really govern and identify where assets are distributed if those assets are in someone's estate at the time of their death. Now, when we think about assets outside of just real estate, we can think about checking accounts, brokerage accounts, things like that. So those assets are not always going to fall to someone's estate. So again, the will only is going to govern what assets are in someone's estate when they pass away. An asset may not fall to someone's estate if there is a surviving joint owner. So if someone passes away and that asset is owned jointly with another individual, such as a joint checking account, or if the piece of real estate is owned with a joint owner, that joint owner is going to take control of that asset 100%, whether or not the will says so or not. Another way that assets are going to pass are via beneficiary designation. So if someone has a beneficiary designee on an account at a financial institution or such as that transfer on death deed, that asset is going to go to that beneficiary. It does not matter what is stated in the will. You can kind of think of joint ownership and beneficiary designations as instructions. So when someone passes away, there's an instruction on where that asset is going to pass. So in turn, everything that doesn't have an instruction, that is then going to fall to someone's estate and be distributed per the terms of what is in their will. A specific example of when a transfer on death deed can really alter one's goals besides just identifying that it's going to go to a new beneficiary. If, for example, if we are leaving a piece of real estate to one of our children in our will, and we identify that another child is essentially going to be getting the value of that piece of real estate in their share of the inheritance for the assets that are distributed per the terms of the will. Well, if we have put beneficiary designations on everything, if we've utilized transfer on death deeds, we may not have anything that is left in your estate when you pass away. So in turn, this can really create a very large imbalance of the distribution of your assets, where you may be leaving a larger amount or percentage to a certain child. And that can definitely cause some issues down the road if one of your children feels like they weren't treated fairly, or there was a mistake, or their other sibling got more favorable treatment. It's going to be an emotional time when you pass away. And the last thing that we want to do is cause an issue where, now we have siblings not getting along. So it can really just be a major headache for everyone involved. So that is why it is very important that if you do a transfer on death deed later on after you've completed your will or your trust or any estate planning documents, you need to make sure that you are working with an attorney who can verify that the new documents that you're doing, they're going to still follow your goals for what's identified in your estate plan. And it's not going to cause any issues with anything when you pass away and those assets are distributed accordingly. So I'd like to thank you for joining me today. If you're interested in learning more about estate planning or real estate or probate, feel free to subscribe to our YouTube channel, and then you'll be made aware when we post a new video. Thanks. Have a great day.